So Chambers, I'd like to call this joint hearing of the Criminal Justice and Judiciary Committee and the Rules and Reference Committee to order. Today in Ohio, some residents can legally possess marijuana products. Some can enter into a business regulated by the state and walk out of the door with marijuana. In another part of Columbus, possessing marijuana jeopardizes a clean record, a good paying job, and his family's stability. We're here today because our criminal justice system is not just because antiquated laws are hurting Columbus families, especially black and brown neighborhoods. We're here today because there are thousands of fathers, mothers, brothers, and sisters who have trouble finding work because of low-level drug offenses. And we're here today because despite begging our kids not to do drugs, they can sometimes be persuaded to do so. And we have a responsibility to support them and give them opportunities for redemption. Tonight, we'll hear from local experts about the impact of marijuana penalties, how these penalties and associated records create barriers to employment, and what tools are available to the City of Columbus to ensure all residents have access to good-paying jobs. I'd like to thank Councilmember Shayla Favors for co-chairing and convening this hearing with me. I've appreciated her leadership over the last several months as she jumped right into this issue and has been so important to moving us to this point. I'd certainly like to thank our President Pro Tem of Council, Councilmember Elizabeth Brown, Councilmember Mitch Brown, and Councilmember Dorans for joining us, for Solicitor General. Thank you so much, Ms. Laura, for being here. And at this point, I would like to turn things over to Chair Favor.
Thank you, President Hardin. Good evening, everyone, and thank you for taking time to be here. To my colleagues, thank you for your presence as we continue to have this conversation in our community. I'd like to acknowledge our area commissioners who have joined us this evening as well. The intention of this joint hearing is to examine the local impact of marijuana penalties and how these penalties and associated records create barriers to resources and have a negative impact on an individual's quality of life. When people are arrested for possessing small amounts of marijuana, they are likely to face collateral consequences that can affect their eligibility for public housing, student financial aid, employment opportunities, child custody determinations, and immigration status. The effectiveness of criminal justice reform lies in our willingness to fix the perceived errors and unintended consequences of our criminal justice system. All across the country, there are movements focused on reforming discriminatory sentencing, policing efforts, incarceration numbers, juvenile justice, and drug policies. Some of these efforts are driven by nonprofit organizations, while other efforts have been driven by cities who are evaluating the pursuit of nonviolent policies and their impact on reducing crime and its ability to address overall public safety concerns. Further, the data we will explore today demonstrates the disparate enforcement on marijuana laws. National research has consistently shown that Black people are almost 4 times more likely to be arrested for marijuana possession than whites, despite individuals of both races using marijuana at the same rate. The disparities in enforcement remains consistent even in cities where marijuana use has been legalized. With the onset of legalized marijuana in the state of Ohio, it's important for our city to have a conversation about enforcement and its impact on public safety, the resource drain to our officers and prosecutors, and disparate enforcement. I want to be clear. This is not a hearing that is promoting drug use or drug trafficking or discouraging enforcement of the law. This hearing has been convened to have a critical conversation about our penalties associated with nonviolent, low-level marijuana possession. We have several speakers that will provide substantive information around the topic that have joined us this evening. On our agenda, we have Doug Berman with the Moritz College of Law, Drug Enforcement and Policy Center, Senior Legal Analyst Kyle Strickland with the Kirwan Institute for Study of Race and Ethnicity, and a staff attorney, Patrick Higgins, with the Legal Aid Society of Columbus. Also joining us, we have Solicitor General Laura Baker Morrish with the Office of City Attorney Zach Klein, and John Oswalt with the Columbus Council research staff. Thank you all for providing your knowledge and research, and we can go ahead and get started. If Mr. Berman would join us at the podium. Thank you for being here.
Good afternoon, Council President Harden, Councilmember Faber, other members and staff of the City Council. My name is Douglas Berman. I'm the Newton D. Baker and Hostetler Chair in Law at the Moritz College of Law, and I direct Ohio State's new Drug Enforcement and Policy Center. I truly am grateful for the opportunity to testify about research and reform efforts relating to marijuana penalties and their impact on employment and other professional and personal opportunities. Because our center conducts research on a national scale, and because I know others will be testifying about Columbus-specific realities, I'll focus my testimony briefly on some national and statewide developments. As you know, there is widespread and I think quite justifiable concern about mass incarceration, mass punishment in our nation, and particularly the significant role that drug enforcement plays, not only in formal punishment systems, but in extending the punitive consequences that an individual may face when caught up in the criminal justice system. Even with more jurisdictions legalizing marijuana for various purposes, arrests for marijuana offenses are still remarkably common. 660,000 marijuana arrests took place in 2017, according to the FBI, the last year there were statistics. In some recent years, the U.S. averaged 2,000 marijuana arrests per day. Think about that. That means nearly 100 persons being arrested every hour of every day throughout the entire year. Now, of course, many marijuana arrests do not result in a conviction, and not every marijuana conviction results in incarceration, but plenty still do. More importantly, for the purposes of our conversation here, an arrest alone can have a significant and potentially lifelong consequences for employment and other professional and personal opportunities. Especially disconcerting are the significant and persistent racial disparities seen in marijuana arrests and convictions that have been repeatedly documented in every single jurisdiction across this country in which the issue has been carefully studied. The ACLU report, which I think you referenced, Chair Faber, took stock of nationwide data and concluded that African Americans nationwide were on average 4 times more likely than whites to be arrested for marijuana possession. Importantly, especially here, these disparities do not reflect only rural or southern enforcement patterns. In fact, a follow-up study in Minnesota determined that that state had double the national average of disparities in marijuana arrests, and that the counties in which the largest cities were located had even more extreme racial disparities in their arrest patterns. And these well-documented and consistent racial inequalities exacerbate the injustices and harmful consequences that can flow from punitive and excessive marijuana enforcement as marijuana offenders deal with the lingering effects of a criminal record which can impact lives long after a formal sentence is completed. Depending on the jurisdiction and the offense classification, persons with a marijuana conviction may lose the right to vote, to drive a car, to serve on a jury, to own a firearm, to adopt a child, and to participate in various professions. These persons may also find it significantly more difficult to get a job, to rent an apartment, to access housing, to obtain credit, student loans, preserve parental rights. It goes on and on. Focusing specifically on the direct employment consequences of a marijuana conviction, those come in the form of state laws that expressly exclude persons with certain convictions from certain jobs or licenses. Focusing on Ohio now, a recent report by Policy Matters Ohio found that, quote, of nearly 1,100 collateral sanctions in the Ohio Revised Code, over 850 of those restrict access to jobs, including more than 250 that restrict employment in specific occupations and 600 that restrict licensing, contracting, or other paths to livelihood. There are also, of course, employment consequences that are less formal, but no less consequential, when industries and businesses avoid hiring people with criminal records, purportedly because of liability concerns. In fact, a recent Wall Street Journal article highlighted because modern technology has made it easy for anyone to pull up an arrest record in a minute, even those who have never faced charges or have had charges dropped find that a lingering arrest record can ruin their chances to secure employment, loans, and housing. Now, encouragingly, state legislatures, federal legislature, the general public, starting to express ever greater concern about these myriad costs of the war on drugs and the punitive treatment of less serious criminal offenders. These concerns have led officials and voters in many states to embrace new laws and practices intended to reduce incarceration levels and ameliorate these enduring harms of a criminal conviction. Giving you a sense of where this hearing fits into a broader national landscape, a recent report from the Collateral Consequences Research Center, quote, since 2013, almost every state has taken at least some steps to chip away at the negative effects of a criminal record. That's great, but chipping away really is not enough given how long-standing those consequences are. What's exciting and interesting and important not to lose sight of is that the reforms in this space have been diverse and dynamic. For example, 5 states have reclassified all forms of simple drug possession as misdemeanors rather than felonies. Of course, that was one of the proposals in Issue 1 last year. It's being discussed in the General Assembly right now. But what I think it's important not to lose sight of is this group of defelonization states. It includes a few blue states, California and Connecticut, but actually an even greater number of so-called red states. Alaska, Oklahoma, Utah have all done this defelonization of all drug possession offenses to bring them down to misdemeanors. Focusing on marijuana now, we've seen diverse states, including states you might not expect, Mississippi, Nebraska, New Hampshire, to have fully decriminalized the personal possession of marijuana. And focusing on what cities can do, I know you'll hear later about limits under existing law here in Ohio, but we've seen cities nationwide, again, including cities in states you might not expect, Florida, Georgia, our neighbor Pennsylvania, Texas, have enacted municipal laws or passed resolutions that either fully or at least partially decriminalize minor marijuana possession offenses. At both the state and local levels, as marijuana legalization and decriminalization has become more commonplace, so too encouragingly have been efforts to enable persons with past convictions to seal or expunge their records. California here is leading by example. Their 2016 legislation or initiative authorized expungement of past marijuana convictions, and then a follow-up piece of legislation in 2018 made that process automatic, so that state officials and local officials were charged with initiating the expungement process rather than putting the burden on the individual. And in fact, advocates, myself included, looking at how to remediate the lasting punitive effects of the drug war and punitive enforcement of even low-level marijuana offenses, think that trying to make as automatic as possible record-sealing efforts ensure its effectiveness, because we've seen that if the burden is put on the individual to seek expungement of the record, the process can get complicated, expensive, time-consuming. It may put the process out of reach for too many. Importantly, and this is a very recent piece of research that I think is so compelling for the work that you're doing right now, it's not just the individual, the general public benefits when society helps move people beyond a criminal conviction and enables them to better participate in the workforce. It's a new empirical study out of Michigan, sorry it's out of Michigan, but that's what we've got, found not only that those who obtain expungement, quote, experience a sharp upturn in their wage and employment trajectories, but also that these persons have, quote, an extremely low subsequent crime rate comparing favorably even to the general population. In other words, we can and should expect both justice and public safety to be well served if we take effective efforts to remediate the lingering impact of punitive marijuana enforcement realities. To conclude, I really am eager to thank the City Council for giving attention to these important issues and to encourage everyone to recognize the roles they can play in moving the community forward in this arena. Literally, just earlier this week, I received an email highlighting a successful marijuana expungement effort in the city of Sacramento that involved a council member, the local public defender, and the local DA's office, other state governmental offices, as well as local, state, and national public health and criminal justice advocacy groups. The email reminded me that eliminating barriers to employment necessarily is an all-hands-on-deck type enterprise, and I fully support the work of this council and all others in this community exploring the means to ensure residents have robust access to employment and other professional opportunities, and I'm eager to use our center and whatever tools I have to help with that effort. And with that, I thank you very much for the time.
Thank you, Mr. Berman. Any questions or comments from my colleagues? So just in your analysis, in review nationally, what came first, the chicken or the egg? So did you see reform and then legalization of medical, or was it the reverse?
You know, it all has a way of synergizing on itself, in part because a number of folks express a variety of, I think, well-meaning concerns about whether it's medical marijuana reform, whether it's decriminalization, whether it's expungement. What if we do that? Are we sending the wrong signal to the community? And as those reforms move forward, and not only don't the worst fears come true, but in fact, all of these benefits are shown. The opportunity for people to get back into the workforce, the degree to which that helps them stay off a bad path and on a good path, the way in which it's not just that individual, but the community they come from that can be more optimistic, seeing the law working for their favor. We've seen really positive outcomes from all of these reforms, particularly when they're focused on these low-level type offenses, which, again, the disparity in arrest rates, just highlight why the sets of perceptions about the unfairness of these laws kind of are so robust. And then there's lots of research about how people follow the law they respect, and they're less likely to follow laws they don't respect. And if they see these disparate enforcement patterns and they don't think the law is working for them, so to speak, they're much less likely to care about any of the laws. But then when you make these efforts and people see really, hearings like this that show that the government is sensitive to these issues and are trying to remediate them, it seems to have, positive benefits that then lead to more comfort level doing more and going further and further.
What have been some of the objections you have just seen on a national scale to reform in this arena?
I think actually some of the concerns are ones that you even spoke to at the beginning of this hearing, that you're sending a signal, right? And that it's important to make sure we tell people, don't use drugs irresponsibly, don't head down a criminal path, and if you reduce penalties or you make it easier for people to expunge their records or get away from a criminal past, you send a signal that it's not that big a deal, and that you don't use the full force of the law to encourage people to behave differently, behave more responsibly. What I think the problem with those claims is it's built around an assumption that people have respect for a law that may be true in certain communities but isn't in others if they're feeling like the law is not being applied fairly. If they feel that there are certain individuals who are always getting arrested and others who are never getting arrested for the same kind of behavior, to say we shouldn't send the wrong signal, the law's already sending the wrong signal in the way it's getting enforced. And so I think it's an easy type argument to make when you're not either from a particular community or had a particular experience that leads you to question the signal the law is sending in the first instance.
Thank you, Mr. Berman. Oh, yes.
Thank you, Chair. Has your center seen any research on just the effectiveness or the difference between a councilmatic-led effort for penalty reduction versus citizen voter-led? And is there research out there?
It's a terrific question. It's actually one thing that I'm continuing to sort of be eager to work on, because what we really end up seeing is when an initiative drives reform, then a greater number of legislators, whether at the city level or the state level, say, well, that's what the voters want, we should feel comfortable doing that. And I think there tends to be, and we've seen this in just about every state with full legalization, an anxiousness about going first as representatives when you're not sure what the people want, but when the vote comes in, then you move forward, right? And so even at the city level, there have been a number of folks who have put even decriminalization initiatives on city ballots in an effort to kind of undermine that. But there's no research that I know, and I don't think there's really it would be awfully hard to measure whether you have different impacts when you change the law depending on how it gets changed. Again, I think it impacts the legislators. I'm not sure it directly impacts the way the voters, and in fact, at the risk of insulting myself and others, my sense is lots of people, they know maybe when the law is changed, but they're never quite sure how it got there once the law has been changed, and that's itself part of what's so dynamic in this space. Obviously, here in Ohio, we got medical marijuana reform through the legislative process, but kind of in the shadow of different ballot initiatives. And so what I've really noticed is how these things move together. And I will say, and this maybe is the right way to articulate it in this context, and we saw it with the General Assembly here, if legislators don't move forward, whether it's at the city level or the state level, voters on these issues are inclined to take matters into their own hand, right? They're inclined to move directly to the ballot because they know how popular this is and how consistently these kinds of issues have passed through a direct initiative. And so, my advice has always been, in this context, if you want to kind of retain control over the complexities of these issues, it's important for the legislatures and the city councils to be leaders rather than wait for the voters to go directly, and often it will be advocates designing their perfect bill rather than maybe what responsible representatives think are the right way to balance some of these issues.
Can you talk a little bit more about some of the the difference between the cities and states reforms that you've seen? And we are functioning in a state regulatory environment that kind of lags Columbus's natural progressive instincts, and it is a challenge in many subject areas, and I think this is one. So I'm curious if you have observations from other cities that might loosely track that context.
Yeah, I mean, it's a wonderful question, and it's one that comes up more and more as cities, particularly in sort of less progressive states, but that are progressive themselves, want to move ahead, whether it's on decriminalization, whether it's on kind of changing enforcement patterns. And I really think it's critically important for anything the city does to have as much buy-in as possible from some of the statewide actors rather than get sort of bogged down in a fight over some of these issues. I'll give you just one remarkable example that I was speaking to reporters about earlier this year. In the city of Baltimore, there the city prosecutor said she's not going to prosecute low-level marijuana offenses anymore, and the city police, unhappy with that, said, well, we're still going to arrest people. And so that really kind of defeats, most of the people who got arrested wouldn't get prosecuted anyway. I think there was, if there was more sort of trust between the actors in the system there, the prosecutor would have reached out to the city police and said, look, how about we work together to figure out a way to have the right kind of policy that even whatever the statewide policies are, we can do the kind of reduction of priority of enforcement that works well for our city. And so I think there's two layers to it. One is not just figuring out what space you legally and politically have as a city to move forward on some of these frontiers and working with various state actors to be effective in this space, but then also making sure you're working with other city folks and the community writ large to make sure whatever you do has the greatest impact, right? Because that's really sort of, for me, the broadest story here is marijuana enforcement, marijuana laws generally, the law on the books and the law in application can deviate dramatically, right? And again, for me, my favorite example lately is Ohio passed its medical marijuana law back in, 2016. Yes, that was so long ago, and we only got stores, operational earlier this year. Oklahoma passed an initiative, in June 2018 and had their medical marijuana stores up and running before ours were, right? And so that's what difference it can make when different actors in the system are working in different ways, not necessarily irresponsible, but with different sets of priorities to their community and the like. And so I think it's a great question about how you work through that. And I think, candidly, it's a question that those of you who work on the ground in the city will probably have a better sense of than those of us who work in the ivory tower and can look at the broad perspective, but can just lead to the conclusion that you're going to have to do that work with other constituents in this city and throughout the state to make sure anything you do has the effect you want it to have.
Thank you very much.
Thank you so much. I really appreciate it. Thank you.
Up next, we have Mr. Kyle Strickland with the Kirwan Institute. You could join us. Thank you for being here.
Thank you, Council President Harden, Councilmember Favor, the rest of Columbus City Council for allowing me to be here to testify today, and also, more importantly, for having this conversation, this important discussion around the issue of decriminalization. Here at the Kirwan Institute, I'm a senior legal analyst at the Kirwan Institute, and a lot of my research is focused on not just what we're doing around issues of decriminalization, but the impacts on race and the racial disparities. And it's been brought up by Professor Berman as well as Council President Harden and others about the issues that we're facing when it comes to racial disparities in our criminal justice system. When we talk about marijuana decriminalization, we cannot talk about that without talking about the very real factors of the war on drugs. The war on drugs that has largely begun 40 or so years ago has largely been a failure. It is focused on increasing it's focused on reducing crimes and issues in order to increase public safety, and yet we have not seen that. And instead, we've seen entire generations, particularly communities of color, who have been locked up and kept away from their families, often for small, low-level, nonviolent possession cases, just like what we're talking about today. Decriminalization is important because when we talk about decriminalization, we can't just talk about one low-level drug possession crime. We have to talk about what that leads to in the rest of the criminal justice system. Getting caught up in the cycle of the criminal justice system causes further and further problems. When we do the research, when we look at these issues, we know that we can't look at the criminal justice system without understanding the very real policies and practices of all of the actors that play a role. So, for example, when we talk about reducing racial disparities in the criminal justice system by decriminalization, we must always have the focus on specifically language around race and the actors that enforce it. In Philadelphia, they moved to decriminalize drug possession for low-level, nonviolent drug possession of marijuana. And what we saw is, while we saw the reduction in arrests, which is important all across the board, we still see the disparities that persist. And so even if we move to decriminalization, which is a necessary step to make, we also have to have a conversation around ensuring that all actors are enforcing the rule of law in a manner that is fair and consistent. Far too often, we've normalized this process of black and brown communities being arrested at 3 to 4 times the rate of white counterparts, even though they use marijuana at roughly the same rates. And we've normalized this because it is in the DNA, unfortunately, in this country of systematic and institutional racism, and we can't be afraid to have that conversation. And I know some people get uncomfortable when we talk about the issue of race and division around this particular issue, but we're not just talking about individual actors. Because while racial bias plays a role, the problem with systematic and institutional racism is that it permeates all throughout our policies, our practices, and our institutions. And so when we make changes for decriminalization, because that is the necessary step that needs to be made, we have to have those broader conversations on other actors. We have to have conversations with our prosecutor's office. We have to have conversations with our police department and what enforcement looks like, to ensure that we're no longer just using an excuse of perhaps maybe having a smell of marijuana and then using that to do a search and finding other sorts of activities that lead to further crime. And then what ends up happening is that we continue to over-police and over-surveil communities of color. We continue to criminalize those in low-income communities. And these are the same communities that, if they were a little further north or a little further west, that they would just kind of turn away and say, well, that's a slap on the wrist, let's move on. That's part of growing up. And yet, we have young black and brown boys and girls who are seen at ages 12, 13, or 14 as adults who are tried as if they are violent offenders. We want to make sure that, yes, folks may make some mistakes, but that shouldn't be the end of their ability to make an impact in this society, to be able to thrive and be a part of this city and this community. And when we have this conversation, people may disagree on whether or not you have a broader conversation about legalization, but at the very least, we have to have a real conversation about why these disparities continue to exist. We've accepted it. We've allowed these disparities to exist. And so what we're going to do is have small changes on the edges and expecting some sort of change. But we cannot accept that. We must be bold and demand bigger and broader solutions. There's only so much that a city can do, but leaders can step up, have these conversations like we are right now, and encourage state lawmakers, other policymakers to have a broader conversation about why we continue to lock up and put away communities of color as well as those in low-income communities. And our conversation around this particular issue does require the hard but necessary conversations. We talk about the Columbus way often, and we do great. We have a wonderful spirit of collaboration here in Columbus. We're able to get the private sector involved. We're able to get public officials, local leaders involved to address particular issues. And we can do it to save the crew. Surely we can do it to save the millions of people who get locked away because of low-level offenses or a criminal justice system that is completely broken. We have to have that same urgency around these issues. And wherever we fall the political spectrum, we have to understand and realize that race is a huge factor and a huge piece of this. And until we confront that issue, we will not address it. And so when we look at this particular issue here today, when we talk about race, when we talk about structural racism, we have to have folks understanding the issues and what that does for our society, because that will permeate. There are specific and real policies and practices that were put in place. So, for example, in Philadelphia and other places, what we want to do to ensure accountability in the enforcement practices, we have to make sure that the police department keeps track of all those who are being arrested or fined for a particular offense, making sure that we're keeping track of the officer who made a particular arrest or offense, keeping track of the age, race, and gender, where it happened, when it happened, making sure that we're keeping track of this so that we understand and recognize where disparities may come up because of these particular patterns. It's about accountability, it's about transparency, and ultimately it's not about criticizing folks for the way things have been. It's about understanding that, yes, we are operating in a flawed system, and we're trying to figure out the areas where we can improve. This discussion around decriminalization is that first area. And some people may not fall on that line because they may have a particular opinion about what it may lead to. But the unintended consequences, what it usually leads to, is still seeing disparate arrests. And so we need to focus on the first step about decriminalization. Then we need to have a broader step about those who have already paid their debt to society and ensuring that their records are expunged or sealed to ensure that's no longer a problem. So I'm confident, I'm grateful that I'm here today as part of this hearing. But I encourage every one of you and everyone at this hearing and in this community to understand that we have to have a real conversation about why it is that we continue to criminalize Black and brown people as well as those in low income. Because unfortunately, our criminal justice system shows that if you make the most, then usually you might be able to find a way to get a slap on the wrist, but those who are caught up in a cycle might not have the necessary resources to navigate it, are struggling and will continue to struggle. It is not fair. We must address it, and I think this is a step in the right direction. Thank you so much.
Thank you very much. So you kind of touched on it just a little bit. I believe it was Philadelphia, the city. What efforts have you seen to discourage disparate enforcement and cities that are starting to move in this direction?
Of course. So it leads to collaboration of all of the various actors in the criminal justice system, having conversation with the prosecutors or whether or not they're going to pursue particular charges, having conversations with the police departments to say, hey, let's actually keep track of these in a more consistent manner so that we're not pursuing these continued acts. You know, what we often see actually across the country, what we see is, you know, the explanation to these disparities are, well, you know, we're tacking on not just marijuana, but other sorts of drug rates and drug issues. But when you actually dig deeper into the data, what you find is that in similar scenarios, similar cases, you are still seeing these disparate arrests and disparate rates. And so it requires really a lot of, oftentimes, accountability and transparency with the police departments and with the prosecutor's office, having a conversation about, we're not going to pursue these low-level nonviolent drug possession cases. We're going to go after more harmful, violent cases that actually affect public safety. And what you've seen are political leaders who have stepped up and said that this is not making us safer. This is continuing to lock folks away. And so that's the first step, but it's not easy. Most cities and states who have done this in terms of decriminalization or even legalization still see these disparate arrest rates. And so I think you need broader conversations. You've got to talk about racial equity trainings within the police department, within the prosecutor's office, within all levels of elected leadership. But going beyond that and saying we're not just going to do a one-off training, we're going to keep data And I think an important piece that they're starting to have the conversation in Philadelphia is regular reports in terms of reporting back with the council, with the prosecutor's office, with the police departments of, making sure that's consistent. I think that's something that we could do here in Columbus. We could make sure that we're keeping that report up regularly and actually being transparent with the public, and so that we're not just kind of scrambling around having to dive into the data or file public records requests. We can be transparent about that and see, when are people being arrested and what types of folks are being arrested. Because, I mean, even in Franklin County, the latest kind of records of the municipal court from 2016 to 2018, we got about 60% or so African-American men being in these same types of possession cases that are being charged. That has to be addressed because that's woefully disparate.
Mr. Strickland, how would you address the issue of biases, implicit and explicit biases on the part of the judicial system? You mentioned it casually as you were discussing it, but apart from just out-and-out racism,
of course,
how do you get to that point of education? How do you try and convey to people that everybody is not the same?
Yeah, of course. That's such a great question. So when we look at bias, at least at the Kirwan Institute, the way we define implicit bias, especially, is the unconscious actions and decisions that influence our actions in an unconscious manner, right? So what that means is we may not necessarily believe in a particular thing, but all of the media, our lived experiences, leads us to have certain stereotypes. And sometimes those certain stereotypes lead to how we operate. And what ends up happening is these stereotypes can lead to broader societal beliefs. So, for example, there's often a stereotype with low-income communities are often lumped in with communities of color because you see this concentrated poverty met with our history of residential and racial segregation, which has led to entire communities being concentrated in areas where they're blocked off from opportunity. And so it's these biases that play a role in how we operate every single day. And so when we're having conversations with people, when we are in the workplace, we might make unconscious snap judgments about people without necessarily believing that. And it's hard for people to really take that in because if you talk about racial bias, people automatically might jump and say, well, I'm not racist. So don't call me racist, and then you just kind of end the conversation. But we all harbor bias. I harbor bias. We all harbor these biases, and we have to learn what to do about them. There's several ways we can do it. There are implicit bias, racial equity trainings. If you're a part of an organization, encouraging your employer to go through these types of trainings for the entire staff, that is an important step. You can also do on an individual level, you can take the Harvard Implicit Association test, which is an actual test to measure biases. And what's important is that at the very least, we have to all become aware that we have these biases, and it doesn't make you a bad person. It's not about being good or bad, but it's about harboring these things that are the result of our experiences and our reflection of our lived experiences. And so the first step is learning and recognizing and admitting that you have these biases and figuring out ways in which to address them.
So would you say that the judicial system has issues with regards to the way in which they address implicit biases?
Certainly. So the judicial system currently here in Franklin County and in the state and across the country has a problem with racial bias. It is a fact that doesn't just affect any necessary individual actors, but it also permeates all throughout our system in which we operate. But it's something that can be addressed, can be changed. Making sure that we're going through consistent training with our judicial members, making sure that we're having conversations within the community, hearing outside of, I think sometimes folks get caught up in the bubble, making sure that we're engaged in the community. And ultimately about bias and about these issues, what I want to get across is that we've got to come to a place where, we can take this criticism, we can take these issues and understand that it is not a direct attack on that particular institution or a particular individual actor, but rather an attack on the system that we're all playing a role in. And so when it comes to the judicial system, there are routes and avenues that we must take on to tackle issues of racial bias, but also issues of gender bias, other issues of bias, of bias around sexual orientation. all sorts of identities play a role, and I think it's a start by having more trainings. But yes, we have to do that in our judicial system, with our police department. We have to do that all throughout our institutions.
Thank you.
Thank you.
Thank you, Chair. Thank you, Mr. Strickland. And I probably should have asked Mr. Berman this as well, but one of the, on the policy part of the conversation that we're within the scope of having as a city is around misdemeanors and low-level possessions and penalties. Can you talk about your thoughts on what the reduction in penalties would mean in terms of the racial component of how folks have been engaged through the system as it is? What I'm getting at is some folks say it's just reducing penalties. Does that even do anything, and what impact would that even have, especially for people who look like you and I?
Yeah.
Is it worth it as it pertains to people of color?
That's a great question. It's a huge difference. For some of us who are privileged in a situation to say, well, you know, it's maybe a slap on the wrist, and that's all you need to do, move on. But you're talking about, you know, upwards of $150 that some people, whether they're living paycheck to paycheck or may not even have a particular job, that could be an entire savings. And so when you're talking about that and you add on that fine, and let's say somebody misses a court date, then you add on further issues, and so that's a huge problem. You know, a lot of the work that we've done around My Brother's Keeper, we know a lot of these families that we're working with, these communities that we're working with, you know, low-income communities that are trying to make it paycheck to paycheck, trying to put a roof over their heads, trying to send their kids to school, and then you add on something like this, that can be entirely detrimental, especially when we have a broader question about, you know, how is somebody going to get to court if they don't have quality child care that's in place, and they can't have a particular instance where they're going to put their child care. So it makes a huge difference. And so for anybody who suggests that it's just a small slap on the wrist, it is not. It is a privilege for them to think that way. It is a privilege for them to think that way. There are real people in real lives that this will affect. This change, a policy change around this issue, will affect real people, real lives, and especially people who look like you and I.
Have you seen any other efforts? Is it both reform and other mitigating efforts such as record sealing, or expungement? Have you seen anything else that could potentially come into play that maybe we have not contemplated that could be effective here?
Of course. So yeah, you definitely have to have decriminalization with additional reform. Okay. So obviously the mitigating efforts around, you know, some communities have kind of worked around particular ways. So let's say for New York City, or in Brooklyn, in New York, for example, you know, they basically said, you know, the prosecutor's office there basically said, what we're going to do is have a conversation about, you know, being able to file kind of expungement and sealing your records and making that process go. More so of a policy and a practice, not necessarily a particular law that was put in place in that particular situation. But, you know, there are ways you can set aside funds to do community events, to say, hey, we're going to do this particular event this weekend or this set of weekends to expunge or seal your record. And then you encourage, you encourage other folks to come in and say, we're going to address these issues. So those are the kind of the immediate. And then the other immediate piece about all this is really about true reform in the policies and practices of the police departments. Because if you talk about, you know, making these changes in decriminalization, and yet the enforcement continues, then you're not really going to solve the problems and the issues. We've got to be transparent. We've got to be accountable about these things. And yes, it requires more work. And that puts a burden on additional departments and additional organizations. But that's when the private sector can jump in. You know, when the private sector and other states have had a conversation, especially when we talk about California, when you talk about banning the box, right? So instead of having a record having a record and not being able to get a barrier to employment, private sector employers are saying, hey, we want to be able to employ folks. We want to be able to have them as part of our community. Let's find out ways in which to get this off their record. So I truly believe that this is something Columbus can tackle. Columbus can lead the way on, even in a state that is lagging behind on these types of issues. We can lead the way on our policies and practices, and with leadership to say, that enough is enough, and we're going to do what we can within the bounds of city law and city code.
Thank you. Thank you, Mr. Strickland.
Thanks so much. Appreciate it.
Next up, we have Mr. Patrick Higgins with the Legal Aid Society. Thank you for being here.
President Harden, Chair Favor, and members of council, I thank you for the opportunity to be here tonight and to speak about collateral consequences of criminal records, what they mean to my clients, and what we do about them here in Columbus. My name is Patrick Higgins, and I am a staff attorney at the Legal Aid Society of Columbus. We are a nonprofit law firm created by the Columbus Bar Association in 1953 to provide legal aid in civil matters that ensures access to justice for economically disadvantaged people in Central Ohio through advocacy, education, and empowerment. Our vision is a just and fair society where we all have the opportunity to thrive and have lives free of poverty. As a member of our small but mighty reentry team at Legal Aid, one of my duties is staffing Legal Aid's Clean Slate Clinic, which is a monthly walk-in clinic where individuals can meet with a volunteer attorney to prepare necessary documents, either to have their records sealed or for certificates of qualification for employment. This is what we're talking about at the back end of this whole process, after folks have already served the penalty, the sentence, what have you, for their crimes. It's awfully important because when it comes to this, employment and housing are often the most critical parts of successful reentry, whether a person was incarcerated or not. Employment or housing are what give us stability. It's what keeps folks out of poverty. Now, when we do this at our clinics, our impact is multiplied and made possible by a committed and generous group of pro bono attorneys who volunteer their times and resources to come to our clinics and assist our clients. The Clean Slate team, especially through our clinics, assists hundreds of clients in criminal record-related cases each year, and we're on track to provide even more assistance this year than we have in pretty much any other year. That's mostly due to some recent record sealing changes, which we're excited about. We're opening this up to a lot more folks, and we're very, very excited about that. For the sake of saying it publicly, our Clean Slate clinics happen on the third Wednesday of each month at the Legal Aid Society of Columbus. Happens at 5 p.m. I'm happy to distribute more information about that to anyone that's interested. So while there are clients that come to us with the personal sense of relief in mind when it comes to sealing their record, the overwhelming majority tell us a resounding story that is with pretty much every single person: housing and employment. Over and over again, we hear housing and employment. Again, these are the biggest factors when it comes to stability in these folks' lives. The barriers to employment and housing created by criminal records has already been mentioned, and there are, these are keeping our fellow citizens out of, better paying jobs, out of advancing in their careers, out of getting to nice, secure, stable housing. So as Professor Berman already mentioned, there was a great study from Policy Matters Ohio called Wasted Assets, the Cost of Excluding Ohioans with a Record from Work, that really quantified and highlighted the stories that our clients are telling us. Professor Berman mentioned the 850 laws and administrative rules that limit job opportunities for folks with criminal records. In addition to that, about 1 in 4 Ohio jobs is blocked or restricted by collateral sanctions to criminal records. Further, that same study found that jobs affected by collateral sanctions pay on average $4,700 more annually than those jobs without collateral sanctions. Again, thinking about that poverty piece that we focus on at Legal Aid, $4,700 is huge for low-income families, for anyone really, but especially low-income families. So before moving on, I want to underscore what the two speakers before me have already mentioned, and that's that criminal records issues are a race issue and a poverty issue. Of the 450 record-related cases that came through our office here in Columbus in 2018, over half self-identified as African American. 65% self-identified with an identity other than white. Now, a little bit skewed from the general statistics we see about criminal justice, our clients coming through the Clean Slate Clinic actually tilt more heavily towards African American females than African American males. I think that says a lot about who's coming through our doors at Legal Aid more than the system generally, but it's something that I think is an important part of this conversation as well in Columbus. all of the folks that we served had a household income of under 200% of the federal poverty level. Now, we're yet to run into a shortage of folks coming through our doors for the Clean Slate clinics. Just January of this year, we had hundreds of people show up to our clinic, to the extent that we actually had to turn folks away and say, come back to the next one, because we simply didn't have the resources, volunteers, and everything in place to meet that demand. Now, we've tempered that down a little bit by meeting some of the demand on the front end, but that demand has not gone away. Especially with the new sealing law, the demand is huge, and we're ready to tackle it. So the sealing of criminal records and obtaining certificates of qualification for employment quite literally change people's lives. When people have criminal records sealed, they can legally treat those records as though they do not exist. Ohio law permits folks, without giving legal advice in front of city council, to answer no, that they have no criminal record once their record has been sealed, when they're answering that application question for jobs. So when folks obtain certificates of qualification for employment, mandatory state law barriers, those 850 that I mentioned earlier in my testimony, those can be lifted. So previously where an employer could say, hey, I want to hire this person, but I simply can't because the law says I can't, if they get the certificate of qualification for employment, those hands are untied. The employer can consider that person. So individuals who reach these milestones, many of whom have arguably never had that first chance because of the way their communities were policed or because of where they grew up, they're given a second chance to work in meaningful jobs, contribute more to their communities, and live lives with opportunity instead of confronting barrier after barrier. I thank you again for the opportunity to speak to you today, and I'm happy to answer any questions that you have, either about our work or anything else going on in the sealing community.
Thank you very much for your testimony. How important is it to have an advocate or an attorney to assist individuals with navigating the court process?
Thank you. That's a good question. It is, without giving too much self-importance to himself, it's a process that can be done pro se or without an attorney. However, even despite the expansion of the record sealing law and eligibility, it's a process that has some very technical exclusions, steps, things like that. Those are things that we try to weed out from our clinics and take in-house so that we can tackle that. But having an attorney does drastically improve outcomes. I don't have those numbers right in front of me today, but having an attorney improves outcomes in cases, whether it's record sealing or not. So it is hugely helpful. I will give a plug. Franklin County does have a self-help resource center at the municipal court on the 6th floor. They do have the paperwork there where a person could go in and proceed without an attorney. It's always helpful, but especially when it comes to low-income folks, we cannot take every case. However, folks that are ready and able to proceed without an attorney can do so. The outcomes do get better.
How cumbersome is the process of getting one's record sealed?
The process, quite literally speaking, it's just a form in the court that you're in. So you have to apply to have your record sealed in the conviction court where the conviction is from. So if I had a record in Franklin County Common Pleas Court and a record in Franklin County Municipal Court, I'd have to apply in each place. It's a process where you would submit an application. Here in Franklin County, we're pretty fortunate that we have standard forms that say, fill in your conviction information here, sign here, and you submit that to, there's a specific expungement window at the municipal court. That's then taken by the court will investigate it, generally hold a hearing on it. At that hearing, the judge will generally make a determination about whether or not the record will be sealed. It can be, a few-month process from when a person files to when that hearing actually takes place.
Okay, thank you.
Thank you. Thank you for the work that you do actually every day in working with our folks pro bono through the Legal Aid Society. For us non-lawyers and for folks who may be following at home, could you give like a base level definitions, record sealing versus expungement, where that falls under the law between the two, where and what that means here in Columbus or in Ohio?
Certainly. So that's actually a really important question and one that I like to talk about a lot. There's actually a legal distinction between expungement and sealing under Ohio law. Expungement, despite the fact that even advocates, attorneys, judges, the court use the terms interchangeably, they are legally distinct. So expungement we generally reserve for survivors of human trafficking and juvenile offenses. There's an analogy that one of my colleagues created that she never gets credit for. So I'm going to go ahead and use that. So expungement, if we're thinking about records when they existed in paper form, is like putting the record through a shredder. It's completely destroyed. No one can look at it. Sealing, which is available to the vast majority of our population, not survivors of human trafficking, not the folks with juvenile records, is the equivalent of taking the records and putting them in a filing cabinet where only certain folks have the key to get into it and look at it. Those are generally police, prosecutors, judges, generally government officials. In the employment context, it's also important to recognize, though, because licensing boards, other state bodies can also see those sealed records. So the sealing, although the court's giving a signal that it's more important that this be kept private, kept away from the public, than it is to have that information public is important, but there still are going to be state actors that can see it.
And with it being sealed, can it be researched by an employer, like online or through online databases? Like, is there a way for an employer to see this information?
In an ideal world, the answer should be no. It's something that when a court seals a record, that should not come up when someone searches it. It's pretty quickly removed from the court docket. They do a very good job of it. The problem that we see sometimes is that there are a few big data aggregators around the country that do sweeps of court dockets, and they collect that data, they store it, and then they sell it to their employers that are saying, hey, run a background check on this person. Now, the reason I say that's in an ideal world is because they're also supposed to be updating that. When they misreport that information after a record's been sealed, they open themselves up to a whole lot of liability under the Fair Credit Reporting Act. So it's something that we keep an eye out for, but it's not super common that it gets out there, but it does happen. But in the general sense, it should not be seen by employers once it's been sealed.
Okay. And can you talk about the cost? So is this free, or is there a cost associated with the record sealing?
Another good question. There is a statutory filing fee to have a record sealed. It is $50. That is, like I said, by statute. However, if a person is indigent, does not have the money to pay that, it usually does not mean you literally don't have $50 in your pocket but cannot afford that expense. The court should be accepting what's called an affidavit of indigency that can waive that filing fee, generally until the back end of the process.
And my last question is around Legal Aid Society's capacity. What, in the ideal engagement from the City of Columbus, what could we do, the city do, to help grow your capacity to do the work that you guys are doing each month?
Sure. I mean, so each month we do these clinics. We get the word out to the best of our ability, both to clients and to volunteers. We could always use the help of volunteer attorneys. So, I imagine there would be some conflict issues about sending city attorneys our way, but, helping get the word out that, hey, our city needs your help when it comes to volunteers. We also very heavily rely on law students and their volunteer time. We have two great law schools in town. It's also, anything we can do to help get the word out is fantastic.
Thank you.
Hey, Patrick, I wanted to know whether or not you could speak to an issue that Mr. Berman sort of alluded to. So obviously we have convictions and we have charges. And having volunteered at these clinics before, you see a lot of charges in addition. And I wonder if you could speak to a moment about the importance of having those sealed or removed from someone's record when it comes to housing and employment. Because again, there's no criminal conviction there, right? There's no sanctions have been put in place by the criminal justice system yet. Those things are coming up when you do these background checks that are serving as a barrier to employment or housing. So I wonder if you could speak to that for a moment.
Certainly. So yes, non-convictions, dismissed cases, non-prosecuted cases, those do show up on a court website when a person searches someone's name. That is something that can be sealed as well. Clients should not be charged for filing for sealing simply dismissals, non-convictions. Franklin County is very good, fortunately, about acknowledging that. The impact of sealing those is huge, though. Despite the fact the law says that employers should not be considering non-convictions, non-prosecuted charges as signs of criminal acts. It's just we don't live in that perfect world. People look up the name, they see the case number. They don't take that next click to see what the outcome was. That's true in the employment context. It's true in the housing context as well. And so those charges, simply charges, could be just as detrimental sometimes to the unscrupulous or for the unscrupulous landlord or employer.
And just one more time, can you reiterate the Clean Slate Clinics availability and times, hours?
Certainly. We do them on the third Wednesday of each month at the Legal Aid Society of Columbus. We're at 1108 City Park Avenue, which is just south of downtown off of Thurman. So again, we open up at 5 o'clock and every third Wednesday of the month through the rest of the year.
And you're always looking for attorneys to help out?
Yes, we are.
Wonderful. Thank you so much for being here.
Thank you.
Up next, we have Solicitor General Ms. Laura Baker Morsh. Here you are. She is with the Office of the City Attorneys at Klein. Floor is yours.
Thank you, Chair Favor, President Hardin, other esteemed members of council. I'm here to talk about things that are a lot less exciting. The current status of the law and what council may or may not be able to do in this particular area. Currently, the Columbus City Code does not address drug possession in any form, and all arrests or prosecutions of drug offenses in the city are pursuant to the Ohio Revised Code. While the city has a great deal of discretion in determining drug abuse enforcement policies and/or alternatives to prosecution, the city cannot itself alter that state law. The city can seek to enact its own drug offense ordinance pursuant to its home rule authority under the Ohio Constitution, but the exercise of that authority is necessarily limited by state law, whereas here the state has enacted a general law on a matter pertaining to police powers. In short, the home rule limitation would prohibit the city from enacting an ordinance that conflicts with state law. Specifically, the city is prohibited from enacting legislation which in any way would seek to create a felony-level offense or would seek to make a misdemeanor that which the state has already criminalized as a felony. In other words, if the state legislature has determined that an offense is a felony offense, a city body is without authority or power to enact a parallel piece of legislation and create it as a misdemeanor offense that would be struck down as a home rule challenge and a violation of the Ohio Constitution. Second, as pertains to drug possession, which currently constitutes a misdemeanor under state law, the city may increase those penalties, and the city may also seek to decrease those penalties, so long as the decrease in penalties does not constitute a, quote, significant discrepancy between the punishments imposed by statute and those imposed by the city ordinance. I've been asked what constitutes a significant discrepancy, and it depends. Generally speaking, again, a significant discrepancy would be going from a felony to a misdemeanor. Arguably, a significant discrepancy would be if the state code had a first-degree misdemeanor with a mandatory jail time and the city enacted a minor misdemeanor. Those would be examples of significant discrepancies. It's worth noting here that the limitations on this so-called decriminalization strategy. In each instance, the initiatives enacted in other cities, such as Toledo, that have been mentioned earlier, they were couched in terms of decriminalizing the conduct, but instead, each in fact resulted in the enactment of ordinances that prohibited criminal conduct that either provided no penalty or made such penalty a minor misdemeanor. So a lot of the conversations that have been happening around the state of Ohio as cities have been engaged in trying to have a conversation about what they can do at the city level have involved the term decriminalization. But in fact, what a number of those cities have in fact done is enact minor misdemeanor violations or enacted misdemeanor violations that carry no penalty. In the case of where they enact a misdemeanor violation that carries no penalty, that in fact is a null law. By definition, in order to be a misdemeanor crime, it has to have both a penalty, a provision, and a sentence. A penalty must accompany it. So to enact a minor misdemeanor possession and say it's zero fine and no jail time, no penalty whatsoever, would in fact be a null act. It's not a crime. And it would have no force and effect. Not just that it's not a crime, it would have no force or effect. Secondly, to enact it as a minor misdemeanor, it still could be considered a crime, and that's something to think about as the city is trying to determine what the best course of action is. To give an example, there was a circumstance under the Ohio Revised Code where they took effort to indicate that a minor misdemeanor drug possession does not constitute a criminal record and need not be reported by the person so arrested or convicted in response to any inquiries about the person's criminal record, and that's a great step forward. What they had not considered in the General Assembly when they enacted that provision of the law is that the conviction itself might still have collateral consequences that could have unintended consequences. For instance, prior to a few years ago, the underlying conviction for a minor misdemeanor drug possession was used as the underlying provision in a weapons under disability charge. Now, that's subsequently been corrected at the state level, so if you give a minor misdemeanor drug possession conviction now, that cannot be used as the basis for a weapons under disability. But at the time, it was, and it hadn't been contemplated. So there's something to consider about the fact that that conviction, that charge, even if a minor misdemeanor, might still be used in other states or federal government or for employment purposes, and even with the best intentions of trying to make it not be constitute a crime here. Third, unintended consequence. Minor misdemeanor offenses, by virtue of the fact that they carry no possibility for jail time, also means that those individuals would not then qualify for public defender services. So that's something to take into consideration as we think about what path the city should be taking. In terms of what the city may be able to do, one of the questions I was asked is whether or not the current misdemeanor of the 4th degree under the state law for possession up to 200 grams of marijuana could possibly be enacted in the city law as a minor misdemeanor. That is possible. That's something that the city could do. Could the city take a look at minor misdemeanor possession offenses under state law and cap the potential penalty at $10 or $25? Yes, that's something the city could do if that's something the city wanted to do. I would also talk a little bit about enforcement actions. A number of comments have been made about the role of the prosecutor's office, the role of law enforcement, and obviously those are conversations that need to take place as well. I would say, having been the chief prosecutor for the city attorney's office for an 11-year period of time, what I can say the general practice of city prosecutors has for some considerable period of time to offer either dismissals for court costs or bond forfeitures on low-level misdemeanor marijuana possession charges. The reason for that is some of it is practical. It's very difficult to get a drug result in time from the crime lab, and it's costly. For other reasons, again, looking at disparate impact and disparate enforcement, it's something that's just simply the right thing to do. It's also important to note as we consider how the city is going to address these issues that currently charging decisions for misdemeanor possession is being made by law enforcement officers within Franklin County. So there's also have to be consideration of who's making the decisions to charge the offenses, at what point is that decision being made. A lot of times it's kind of thought that the prosecutor makes all charging decisions, but that's actually not the common practice in Franklin County for misdemeanor offenses. The last thing I wanted to discuss, and then I'm obviously open up to some questions, are the efforts currently constituting Senate Bill 3, pending before the General Assembly. Most of the efforts that are in Senate Bill 3 that City Attorney Klein and Franklin County Prosecutor Ron O'Brien have been advocating for across the state involve the conversion of low-level felony possession offenses to unclassified misdemeanors. This would, of course, present an opportunity, a great opportunity for our city to look not just at minor marijuana possession, but minor drug possession across the board and how the city treats those offenses. Also contained within Senate Bill 3 are opportunities for reclassifying individuals who had previously been convicted of F4, F5 drug possession offenses to be treated, not actually reclassified, but to be treated as if they were misdemeanors for purposes of record sealing. So as Mr. Higgins had mentioned, record sealing opportunities would be greatly expanded should Senate Bill 3 move forward for those drug possession offenses. Finally, with Senate Bill 3, in terms of marijuana itself, contained within the proposals in Senate Bill 3 is to move the upper limits of the minor misdemeanor marijuana possession to the 200 grams that currently is the possession level for M4s. So if the city is contemplating perhaps enacting a city ordinance that would allow for 0 to 200 grams to be a minor misdemeanor offense, that actually would be in alignment with what the proposal currently is in Senate Bill 3. With that, I'm here for any questions.
Thank you. Could you clarify what the penalties are, fines, and possible jail time currently for minor misdemeanors and M4s or 4th degree misdemeanors?
Sure. Minor misdemeanor offense is currently punishable by a maximum of a $150 fine and no jail time. and a misdemeanor of the 4th degree is punishable by a maximum of 30 days in jail and/or a $250 fine.
And could you speak on resources that are expended to prosecute these types of cases? So we're looking at obviously a prosecutor that has to be in the courtroom. What does it cost a crime lab to test the substance at hand, just in general?
Right. I was going to say, the last time I asked how much it cost to run a marijuana lab was a while ago. But at the time that I asked then, because we were also trying to figure out how best to allocate our resources appropriately and to make a determination as to when in the course of a case we should make the request that the lab actually run that particular test. At that point in time, it was like $78, and that was for the lab test itself. That would not include, of course, the cost of the technician who's conducting the test, not include the court time for that individual to come down and testify. There's a U.S. Supreme Court decision from a number of years ago now that requires in-person testimony of the lab individual who ran the test at the lab, so that person would have to come down and testify in every one of those cases. Also cost in terms of prosecuting misdemeanor possession cases for marijuana, cost for the law enforcement officer to testify in court. That's a mandatory 4 hours to appear in municipal court. And then, of course, the cost that's spread out among the prosecution staff for handling that volume of cases.
Thank you. My colleagues.
Thank you again, Chair. Thank you, Solicitor General. In conversations that we've had, I like that we kept going back to the unintended consequences of doing things or not doing things, and you hit on several of those. Just wondering, so what happens now usually? So if a person is caught with a low level, so within the under 100 grams of marijuana, what typically happens in terms of the city of prosecution?
Okay.
Yeah, what does the typical case look like?
Typical case, and let's talk about individuals who are first or second or third offenders, that kind of situation. Individuals caught with one joint, which is going to definitely be a minor misdemeanor violation. They are generally, the actual joint, if it still exists, is confiscated and kept as evidence. They are issued a summons to appear in court in the Franklin County Municipal Court. They would appear in an arraignment court out on bond, so they would not be arrested. They would appear on their own in arraignment court. They would be arraigned on the charges. They would not have a public defender because, again, it's a minor misdemeanor violation. They would be oftentimes given an opportunity from the prosecutor's office to take advantage of a couple of our different programs that we have. Some of it is dismissal without for the payment of court costs. Some of it will be what we call a bond forfeiture, which is a payment of a bond, but then we don't obtain a conviction on the case. In some instances, if we suspect that there's an underlying abuse issue, we might make a referral to Mary Haven for a drug course or something like that and make an offer to dismiss the case upon successful completion. And a lot of that's going to be dependent upon the circumstances under which they got arrested. If we have an individual that is presenting as potentially having a drug abuse problem, that might be treated differently than an individual who is their first time, first interaction in the court system. It's also possible, a typical case, an individual could also appear in arraignment court, could simply say to the people that they check in with at the court, I just want to get it over with, I just want to plead. Those cases don't always see a prosecutor. They would go right to the judge, and some of those cases do end up in convictions on those minor misdemeanors. Another possibility, again, and this is typical as well, the individual fails to appear in court. That happens. If the individual fails to appear in court, then a warrant is issued for their arrest. And sometimes when you hear about individuals being arrested for low-level marijuana violations, that's the more typical situation. When they have failed to appear in response to a summons, then a warrant can issue even on a non-jailable offense like a minor misdemeanor. If they subsequently then get stopped for speeding or what have you, and the officer indicates they find the warrant, they might get arrested at that point for having failed to appear.
And so under again, if we are as council discussing within the parameters that you discussed, reduction in penalties, how would that change that typical, how could that change that typical path? What I'm getting at is not creating false illusions of what a reduction in penalties actually would mean to folks who are engaged.
Of the scenarios I described, it would have the largest impact on the individual who showed up in court without speaking to the prosecutor and simply pled out. So under that scenario, if there was a cap in the penalty, then of course the judge would not be able to issue a fine that's larger than the cap. I don't currently know the current standard fine issued by a judge on these offenses. And the reason I don't know that is because it is different from judge to judge to judge. Each judge has their own sentencing practices, and so long as it doesn't go over $150, they have the ability and discretion to make that determination. What I can say is that those individuals who are convicted and pay that minimum mandatory fine, the $10 or whatever it might be, would still have court costs that would be associated with that. And those costs, if they are pleading at arraignment, run right around $100. If they plead not guilty and then it gets assigned to a judge, each time the case progresses through the system, there's an additional court cost that's attached to that charge, including the cost to issue subpoenas to the arresting officer to come to court.
Yeah. And my final question, just about Senate Bill 3. Again, we want to applaud the work in a bipartisan manner that is happening between the city attorney's office, the county prosecutor, and truthfully the state on both sides. Do you have any sense of the timeline in which SB 3 is working through the State House?
I'll give you my best guess. My understanding is that there is an intention to have additional hearings for amended substitute Bill 3 within the next month or so. I understand that there is a hope that the Senate will have a vote before the summer recess.
Thank you so much.
Thank you so much. My question actually follows on to Council President Harden. So you mentioned court costs. So if the example of the person, let's call her Jane Doe, that was arrested with a joint and is charged with a minor misdemeanor with a $10 fine, if she just pays the $10 and therefore admits guilt, she gets the minor misdemeanor fine but doesn't get any court costs?
No, court costs are assessed.
So no matter what, they're assessed. And how, you said though, even at that stage, it could be as much as 100?
Yes.
Okay. And then if she comes in the first time to try to plead innocence, there would be additional costs assessed then, and then each additional time? Just trying to make sure I have it totally clear. So.
Right. The court costs are assessed depending upon how much work the court does on the particular case. So there's a standard set of court costs associated with any charge that's filed, and then as that case gets continued, there are additional costs because of the additional notifications, subpoenas, things along those lines. It's like, for instance, if an individual had been charged with a misdemeanor of the first degree and took that to jury trial, there will be jury costs associated with that, and they get larger as the case goes on.
I'm sorry if some of these are dumb questions.
No.
Is there, Patrick was mentioning that you could plead, the $50 for record sealing. If you could demonstrate indigence, you could get that waived.
Yes.
Is that a possibility with court costs?
Yes, it is. A judge is required by statute to impose court costs, but once the court costs are imposed, the judge is also able to hear pleas of affidavits of indigency, and if that is sufficiently demonstrated, the court could then waive the costs based upon that statement of indigency.
Okay.
What often happens, unfortunately, with minor misdemeanor offenses is that a number of the individuals coming in are not represented by counsel and don't know that they can ask for that.
Right. Yeah, absolutely. And then what is being proposed here? So it's like the state, the city crime, which we're essentially creating like a new criminal offense.
Correct.
So the city, like the state, would be a minor misdemeanor. So there would be two possible crimes that if you're stopped by law enforcement, a person could be charged with. And it's up to the discretion of law enforcement to do one or the other.
Yes, I mean, you could not be charged with both. I mean, technically speaking, someone could charge you with both. You could never be convicted of both because they are parallel offenses. But in terms of the decision as to which one to choose, that would be within the discretion of the city police department.
Okay. Okay, thank you so much. Oh, I'm sorry. My last question is the difference between the 0 to 100 grams and 100 to 200 grams. both would be minor misdemeanors, even though the 100 to 200 is an M4.
As proposed, yes.
Okay. And who is it at the state that would have to either disagree with us that this is not a significant discrepancy or agree with us that
The
it is?
Attorney General.
The Attorney General. And if he decided to disagree with us, would they bring suit against the city?
Yes. They would file a motion probably for a preliminary injunction and declaratory judgment, just as they did in Toledo.
Okay. Thank you.
Any additional questions? Thank you. Thank you, Ms. Baker Marsh. And last but not least, we have John Oswalt with the Columbus City Council research staff that is going to provide us with some additional information. Floor is yours.
Thank you, Chair Favor, President Harden, members of council. Tonight I'm giving a brief overview of some of the research behind the liberalization of marijuana laws across the country, particularly more recent efforts in municipalities across Ohio. This will include what some places are doing to lessen the impact of these offenses on individuals' ability to seek gainful employment, housing, licensing, et cetera. If this works, and it does. Just kind of an overview. These are the topics I'll be covering. A quick note on the use of terms. When referring to marijuana, I'm using along the lines of what the Ohio Revised Code does, which encompasses all parts of the plant cannabis. Using decriminalization, I'm meaning a given level of marijuana possession being removed from criminal code and becoming a civil offense. A few places have done that. Many cities and states use the term for lessening criminal penalties. I'm just describing this as liberalization. So discussing those efforts nationally, Pierce Cities, Marijuana and Ohio Revised Code, Ohio municipalities and liberalization efforts there, and some relief from those offenses. So national overview, just a quick snapshot of some of the history behind this, and this is not to exclude advocacy efforts from many different groups on helping to change these laws across the country. 1972, President Nixon's administration formed the Schaefer Commission, named for the former governor of Pennsylvania who chaired it. The commission was made up of physicians, pharmacologists, attorneys, and lawmakers. Among its many conclusions was that marijuana abuse was more of a public health issue than a criminal one, and recommended liberalizing federal marijuana laws. This did not happen at the federal level, but several states took a cue from the commission findings, and various advocacy organizations helped push in that direction. 10 different states, including Ohio, took steps to lessen penalties for marijuana possession in the 1970s. Following this, of course, was the war on drugs through the 1980s and 90s that helped stop further efforts in this vein, with some states actually increasing criminal penalties on marijuana after that fact. I jumped too far ahead here. In the last decade or so, though, there's been a rapid change in the direction of liberalizing marijuana laws. 10 states plus the District of Columbia have fully legalized marijuana. List of states there, and 23 states have legalized the use of medical marijuana, including Ohio. There's been increased attention, as the speakers have shared, on racial disparities in marijuana arrests, and there has been a drastic change in public opinion in a relatively short period of time. For example, using Pew Research, in the year 2000, only 31% of Americans favored legalization. By 2010, it was 50%. In 2018, it was 62%. In 2017, according to a Harvard-Harris poll, 72% of Americans said that possession of marijuana should not result in prosecution or jail time. And in 2015, Quinnipiac did a poll exclusively for Ohio that had 53% of Ohioans favoring legalization of recreational marijuana. So with marijuana liberalization in cities, some cities across the U.S. have begun their own efforts at liberalization, either reducing penalties for possession of misdemeanor amounts or decriminalizing. For the most part, this has occurred in some states with more punitive possession laws, Texas, Florida, Georgia. These are some examples of these cities. Highlight a couple. Atlanta, for instance, by ordinance, reduced the penalties for simple possession of marijuana to a $75 fine for possession of less than 1 ounce, which is roughly 28.3 grams, versus the state of Georgia punishment, which was much harsher, with a $1,000 fine and a possibility of 6 months in prison for possession of the same amount. Kansas City is another. This one was accomplished through a ballot initiative in 2016, I believe, and the penalty was reduced to a $25 fine for possession of 35 grams, or roughly 1.25 ounces or less. The state of Missouri would have fines up to $500 with this. And then Orlando is a case where by ordinance the city was actually able to decriminalize the possession of small amounts, creating civil infraction with $100 fine initially and graduating fines after that for possession of less than 20 grams. This same crime is a misdemeanor of the first degree in Florida with a fine and up to 1 year in prison. So talking a bit about marijuana possession in the Ohio Revised Code, a note on the spelling too. Marijuana is spelled with an H in Ohio's code, as well as in some other state codes. This is just from an older spelling that was used in federal code initially for the Marijuana Tax Act of 1937, which I think is its first mention there. The state of Ohio reduced penalties for marijuana and paraphernalia possession down to the current levels in 1975. In 2016, Ohio took the step to legalize medical marijuana, and first dispensaries opened earlier this year. So these, as has been mentioned by Solicitor Baker Morrish, list the levels of offense by possession, and then the penalty, potential incarceration, and a maximum fine. So as mentioned, less than 100 grams is a minor misdemeanor with no jail and a max fine of $150. 100 up to just under 200 grams would be a fourth-degree misdemeanor with possible 30 days in prison and maximum $250 fine. Anything above that is classified as a felony under the Ohio Revised Code. Possession of drug paraphernalia follows a similar route. Simple possession is a minor misdemeanor. However, the sale of such raises to the level of a second degree. Also, any drug conviction, including a paraphernalia conviction, may result in driver's license suspension for a period of between 6 months to 5 years. This was whittled down a bit in 2016. As prior to that year, some license suspensions were automatic, but it gave discretion after that. Okay, so just within the past 4 years, there have been several ballot initiatives in several Ohio cities to further liberalize marijuana laws. Toledo was the first. Marijuana advocacy groups were successful in passing a ballot initiative in 2015. It passed with about 66% of the vote. It was quickly challenged by then Ohio Attorney General Mike DeWine on the basis that the law had contained unconstitutional provisions, such as attempting to convert state felony violations to misdemeanors, instituting a gag rule forbidding reporting by law enforcement to licensing boards or agencies, attempting to prevent driver's license suspensions, and however did leave in place the changes to the misdemeanors themselves. Since 2016, 11 other municipalities have held votes on ballot initiatives to lessen penalties for misdemeanor possession. All but one have passed. The largest of these after Toledo was Dayton, which put the question to the ballot and subsequently passed a city ordinance writing the changes into city code. I said all the initiatives, but not quite all of them. Eliminated penalties outright for possession of under 200 grams of marijuana. Technically, Dayton's did eliminate these penalties, but only for minor misdemeanors under 100 grams. And as of 2019, Cleveland and Cleveland Heights are also considering measures to liberalize marijuana penalties. These are the cities that had those measures on the ballot. Generally pretty decent in Ohio geography, but I had to look a couple of these up. I wanted to highlight a few of the more distinctive ones. Athens, Norwood, and Dayton passed each with over 72% of the vote. Garrettsville, which is in Portage County, up outside of a little past Kent, or by Akron, failed 52 to 48. So we're talking about effects in Columbus. You've heard the previous speakers detail the effects of marijuana arrests in our state, city, and nationwide, so I'll just briefly touch on a few of the numbers. Since 2016, Columbus Division of Police have brought over 1,400 marijuana and marijuana paraphernalia possession cases to Franklin County Municipal Court. Following national trends, a disproportionate number of the individual charged are people of color. Individuals charged are also overwhelmingly male and younger than the average population. This is a look at the percentages of those cases brought to municipal court and their terminology. African American males represent a little over 62% of those cases. White males, 22%. African American females, 7%. So in looking at relief from some of the effects of those marijuana offenses and some of the ways that municipalities have tried to lessen the impact of the offenses on the offenders themselves, I wanted to highlight a couple. As earlier speakers discussed, record sealing and expungement are one of those. And I apologize if I'm using them a bit interchangeably, but record sealing. Largely done in states and cities where marijuana has been legalized. Some officials have been looking for ways to decrease the number of offenders with marijuana crimes on their records. Other states are also looking to loosen some regulations around expungement to make it easier for offenders to scrub their records of low-level crimes. One of the more innovative and interesting methods for doing this is being carried out in San Francisco, and they just started doing this in the past month in a state where marijuana is legal. San Francisco District Attorney spent this past year implementing an automatic and retroactive expungement process for marijuana-related offenses. It was a partnership with vendor Code for America, and the office flags all eligible offenders in the court database, and then expungement document fields are filled out automatically and sent to the court for processing. This entails no action on the part of offenders and minimal staff time from the DA's office. There's also a call-in line for those with questions about offenses, and whomever wishes to request their paperwork can receive copies. Other California cities, as well as cities in other states that have legalized recreational marijuana, such as in Seattle, Washington, have been readying implementation of these programs. In some states that have not quite legalized, there's also an effort to loosen what had previously been a bit more burdensome process. New Jersey, for example, has passed an ordinance in the past couple of years to allow expungement with completion of drug diversion. Maryland reduced waiting periods for expungement from 10 to 4 years. Missouri reduced the waiting periods and eligibility requirements for marijuana offense expungement. And in Ohio, just this in the past year, we made several changes to this, including expanding the total number of offenses on record. For example, a person would now be able to seal an unlimited amount of misdemeanors. Another way that some places we're looking at avoiding additional sanctions caused by marijuana-related charges are diversion programs. These are already used pretty widely by jurisdictions across the country for all kinds of offenses, including drug offenses. A few cities and states, again, with more punitive marijuana laws have implemented marijuana-specific diversion programs. They're similar to others, typically having an education component, possible community service, and a fee for entry. As a result, the offense is either sealed or removed from the record. A few examples of these are in Houston, Orlando, and Wichita, which are in states that have much more severe penalties when you increase the amount of possession. There is one example I was able to find in Ohio of one of these in Stowe, that's a suburb of Akron. In that program, the offender pays a $550 program fee, which is higher than most, completes an online drug education course, attends substance abuse meeting, performs 24 hours of community service, and then writes an essay on the experience. After all that, the charge can either be dismissed or the record sealed. Barriers to these programs, much like some in the record sealing process, could be the potential cost. In the case of Houston, the main reason stated for not completing the diversion program was the fee, in their case, $150. This process can be subsidized for those who meet certain income qualifications, though, as we see in a few places. And some of the others is that folks just weren't educated on the process and did not know about the diversion program itself. With that, Council President, Chair Favor, Council members, thank you very much.
Thank you very much. Could you highlight in cities that you have evaluated who has been the #1 driver of the initiative? So is it a council-led initiative? Is it a nonprofit organization that's driving that conversation? Do you have a sense of where it's coming from?
Sure. I mean, it happened in all forms, but typically in cities, especially those in the states with much more punitive laws, a lot of the initiative was taken by council itself. It grew from that. Advocacy groups definitely were a partner in that, but it was driven primarily by ordinance and passed. There are some exceptions. Kansas City, for example, put it on the ballot first. In Ohio, it's overwhelmingly been the case that it's been brought to the ballot by advocacy groups. So it runs the gamut.
Okay. And one thing we didn't touch on too much this evening is just the retroactive component, right? So is there a mechanism to assist those who have been penalized in the past from low-level possession amounts?
Sure, and mostly you see that too in the states that have legalized, so that they would have, existing criminal records for something that's no longer a crime. So, for example, in San Francisco, when they were devising a way to do that, they had written a computer program that would search the records all the way back to when they started charging under their local ordinances, and would go through that automatic process. For other places that hadn't instituted that yet, they would have to do it manually to look up to see if they were in fact an eligible offender. Is that something that's available, whether it is legalized or not now, that could be removed from the record?
Go ahead.
I was just wondering, and these are really great other examples of cities, and thank you for such a comprehensive presentation on that. That's very helpful. I'm thinking about Mr. Strickland's testimony on how even when you do work to quote unquote decriminalize or move that direction, there are still problems with racial bias, and how, excuse me, and how the discrepancies between white people and black people being charged with these crimes, and therefore getting them placed on their record and the host of complications that arises anyway. I really appreciate that in consideration of this legislation, you've had the forethought to think through how we may be able to help on the back end. But I'm also curious, he talked a lot about this notion of radical transparency, I guess, for lack of a better term, in kind of reporting out and accountability to the public on who's getting charged. Has that been contemplated in other cities? He used Philadelphia as an example, but there are a lot of cities who have been doing this work. So I'm curious if we've found any other cities really trying to take the implicit bias, implicit racism charge kind of head on.
Sure. Not as specifically and not as part of more holistic program. It seems like they were taking a lot of things like piecemeal, whether it be reviews, internal reviews or external reviews of law enforcement in the city, not dissimilar from the one that we're undergoing now with the Mayor's Safety Commission, but not directly tied to decriminalization efforts typically. A lot of the focus was on legislatively reducing, trying to not so much reduce the disparity itself, but lessen the effect of the disparity, which seems to be the path, like the legislative path most of them have taken. But as there starts to be more awareness, I think we may start to see more examples of a holistic approach like that, but not that I have seen, but if research continues on this, so when we come across that, we'll definitely have that in mind.
Thank you again, Mr. Oswald, for your lengthy research that you've put in, time you put into this process. I wanted to go back to a question or a line of questioning that President Pro Tem was asking Solicitor General around our moving the potential conversation around reduction in penalties and who would then have the ability to make a charge of if that was too large of a change. What's the terminology? Discrepancy. You referenced Toledo as a case where the Attorney General did lean in and say the parameters in which I think that was the case was the voters change were there was a discrepancy, or he put the injunction in, but they stopped at the reduction of penalties. Is that correct?
Yes. So one of the parts where they did find the significant discrepancy, and Solicitor Baker-Morrish could maybe fill in a bit more here too, but they found that principally with the alteration of felonies to misdemeanors, and that was what they targeted for that, as well as a few other provisions like preventing law enforcement from doing any reporting to the state, which they found unconstitutional as well.
Sure.
Mr. Oswald is correct. In the Toledo case, they found that the reduction from an M4 to a minor misdemeanor was not a quote-unquote significant discrepancy. And now that case is not binding on Columbus, but it is persuasive.
Yeah. Thank you.
Thank you, Mr. Oswald. And thank you to all of our speakers for your presenting your expertise and sharing your knowledge in this arena. It is now time to move forward with our public testimony. We do have 10 speakers that have put in a speaker slip to provide some commentary this evening. Each speaker will have 3 minutes to present their comments. As I call your name, please approach the podium. There is a clock that you can now see on the screen that will provide a nice ding upon expiration of the time. Our first speaker, wow. It might be best for me just to, I'll just say 601. Does that ring a bell? No? Okay. Yeah, address 601, number 601. Mr. Frank? No? Yeah. Okay, we'll go to the next one and then call you. We'll try to call you again. Colin Jones. Thank you, Mr. Jones. And if you could please state your name and any organization you might represent or.
Yes, good evening. My name is Colin Jones, and I am the co-pastor of the Advent United Church of Christ Church, along with my wife, Reverend Imani Jones.
Thank you.
Yes, ma'am. Greetings, Council President Shannon Hardin, Chair Favor, and to the rest of Columbus City Council. Thank you for this opportunity to share with you why I am in support of the measure for marijuana reform. There comes a moment in the life of any governing body to determine what is the best course of action to address the application of the law in regards to its citizens. H. Richard Niebuhr, considered to be one of the most important Christian theological ethicists in 21st century America, consistently sought to uphold what is morally right in the context of a larger society, and even challenged his own notions of right and wrong in an ever-changing world. Marijuana has been classified as a drug for a significant period of time, and as a society, our outlook on the classification and its penalty has been relatively firm. However, as times continue to change or evolve, our society is being brought to the table to consider another reality. Just as the evolution of thought in regards to parental discipline has taken place, so likewise, an evolution of thought or re-examination of how we penalize those who have been arrested for marijuana needs to be reconsidered. As the co-pastor of the Advent United Church of Christ Church, I am in favor of reforming marijuana laws for the following reasons. Number one, and it has already been stated, an unequal application of the law. A few years ago, the ACLU, American Civil Liberties Union, conducted a comprehensive report tracking marijuana possession arrests for blacks and whites at the national, state, and county level. According to the ACLU, blacks are 4 times more likely to be arrested than whites, despite similar rates. Number 2, stigma of being a convicted criminal. As is well documented, when an individual has a blemish on their record, the opportunities for employment with better paying careers have been greatly reduced. Many employers choose not to hire individuals who have served time, and this creates a hardship for the individual, which in turn has the potential to send said person back to the place that got him or her into the situation in the first place. In addition to employment, according to the FBI, there have been more than 13 million arrests in the U.S. since 1995. 89% were of possession, while marijuana consumers were not convicted have gone on to be president or Supreme Court justices. A criminal conviction can stand in the way of securing a job, getting housing, or receiving a professional license, student loan, food assistance, driver license, or firearm. Thank you very much. Yes, ma'am. Thank you.
Thank you. Okay. Priscilla Harris. Welcome to council, Ms. Harris.
Good afternoon, everybody. I'd like to thank you guys for having me here. I'm part of Sensible Movement Coalition as well as Appalachian Normal Lobbying Advisor. I'm also one of the team leaders for the Sensible Cleveland marijuana ordinances that we're currently working with City Council, doing a work group hands-on with them to possibly enact the same legislation, the 200 grams down and no fine, no jail time. As you've seen, the group back here is a big part of the force that has hit the citizens' initiatives and got them onto the ballot. So you're going to hear from our executive director, so I'm not going to take up a whole bunch of your time. You guys heard about the racial disparities and everything, so I think you guys will do the right thing for the people. I did lose my kids back in 2008 due to dirty urine for marijuana. So I do want you guys to know that it does have a collateral impact as a single parent now. I lost my fiance to stage 4 cancer back in November. So with the medical program, it is available, but I'm telling you, like with some of the systems, there's a lot of flaws going on, and I would really recommend expanding access to everybody. Thank you.
Thank you, and thank you for your candor and your willingness to just be very candid about your experiences. Tim Johnson. Welcome, Mr. Johnson.
Good evening. Council Chair President Harden and Councilor Chair President Harden and Chair Favor. Forgive me, but I'd come prepared to listen tonight, and after hearing some of the testimony, I decided to go ahead and participate. My name's Tim Johnson. The last 4 years I spent over at the State House creating, implementing, and following up on House Bill 523. Currently, I'm working on Senate Bill 57, the hemp bill that's in progress. What I'd like to bring to your attention tonight is some considerations, just some things for you to think about. And I applaud you for your attempts and what you're trying to do here with the Decriminalization Act. I prefer the liberalization myself. Decriminalize still has the word criminal in it. So I have a problem with that. I do, as I said, I prefer the liberalization. I'd like to bring up the fact that the mere reason we're here, the word marijuana itself, the foundation of it is based on racial disparity. And yet we still use that word as we did in our medical program, the Ohio Medical Marijuana Program. I pled with them to use the word cannabis. It wasn't going to happen. I plead with you. Let's get away from the word. Let's go to cannabis. Let's use what it is. As we continue to use the word marijuana, J, H, or G are all three appropriate. It's a slang name. It's a street name. Let's take that out of our laws and use the proper language. As the gentleman in the back mentioned, in 1937 was when our government first started addressing cannabis. Never in our history that I'm aware of has there ever been a health or a public crisis because of the use or consumption of cannabis. It's never been found. Never in the history that I've found where criminal enterprise was around the production, the use, the consumption, whatever it may be, of cannabis until, as he said, the 1972 war on drugs was created and the Controlled Substance Act was implemented by President Nixon at the time. Some thoughts to consider there. Why did we get here? What's the purpose of being here other than what we're discussing? I would ask that you include in your liberalization not only the limits, but paraphernalia, drug abuse, and any other charges that may come out of that as well. Consider that. I would ask that you also consider the civil infraction as other states have done, and let's take it out of the criminal codes. And to include a forgiveness act for people in the past, for nonviolent crimes. And to please take a look at employment. Expungement and sealing are fine. The problem is they don't get expunged or sealed on social media and at the bottom of an employment request application. They're still asked. Senate Bill 3, I appreciate that being brought up. I ask that you review Senate Bill 1 as well as it pertains to the overregulation of laws in Ohio. With that, I thank you and appreciate you for the time.
Thank you. Solicitor Laura Baker Morrish, could you speak to the notion of making this a civil infraction? Is that a possibility?
It would be a possibility at the state level, but not a possibility at the city level, so long as the state has made it a crime. There are ways, like as we were learning with some of the traffic violations, to make civil infractions out of various behaviors. I can't think of how we would do that with actual possession, because it's a pretty simple act in and of itself, simply to possess. And if we were to enact a statute that is solely a civil infraction, it would be struck down as being in conflict with state law, which makes it a crime.
Thank you very much. Thank you, sir. Up next, we have Mr. Bill Schmidt, Jr. Welcome.
First, just let me say I appreciate you guys having this conversation and being progressive-minded city officials that really want to see change and progressive things come for the community. I appreciate you guys even doing this. But I am Bill Schmidt Jr., and I'm with the Sensible Movement Coalition. We have got 13 initiatives on the ballot. He was just referring to the cities, Bel Air, Toledo, that we have made the ballot. And we have decriminalized 11 of the 13 towns, so we're 85% at the ballot box. What we want to do is try to possibly work with you guys as well, because what we do at the citizen level is very effective. Like I said, 85%. And we also worked with Dayton, and they enacted, instead of 200 grams, just enacted 100. What we could do is we could help work with you guys to help to form the correct decriminalization ordinance to put in place right here. And one thing that we've really been talking about today is like racial disparity. And one thing that we really do with the Sensible Movement is we take the fine down to 0. When we take the fine down to 0 versus 25 or 100, it levels the whole playing field. So there's no racial disparity. There's no way to pick on somebody being a guy, a girl, anything like that. So that's something that I do believe that you guys really need to look at, because that is a huge part of this conversation. And the really only way to really combat that, besides going through a whole plethora of other problems to try to figure out, train these people how to do this, train these, 0. If I get pulled over with minor misdemeanor amounts of cannabis, it's the same as the next person. I have had 8 possessions of marijuana in Ohio. I am somebody who have paid my child support. Both of my kids are 18 and 19. Paid my child support the whole time. Got custody of my daughter halfway through. I don't drink, I don't take pills, I don't do anything. I got into a car wreck and I choose to use cannabis, which is safe, versus other things that the doctors and FDA-approved medications that they may give you. Because there are people out there that have to deal with children because of the other parent had a choice to go down the wrong road and take some of this FDA-approved medication. Now every single day people have to live with children that have parents that have made the wrong decisions. And I'm trying to make the right decision and to make sure that you guys do the right decisions moving forward. So people like me who choose to just use cannabis as medicine, instead of some of the doctor stuff or the medicine that they give you, you know, I should have that choice. But if you guys would like to work with us in any type of way, we have our director back here, and we're more than happy to work with you and help forming this law.
Thank you, Mr. Schmidt. Solicitor General, I'm wondering if you could just kind of touch on the notion of reducing the fine down to 0. Does that not hit on the significant discrepancy?
I don't know if it would hit upon the significant discrepancy, but what it would do is create a nullity. So in order to constitute a crime, you have to have a prohibition and a penalty. So unless there was going to be something else that was going to be offered up as the potential penalty, if you were to charge somebody with a crime and have no potential penalty associated with it, then you have not, in fact, enacted a crime, and it would be an unenforceable law.
Okay, thank you for that clarification. Thank you, sir.
Thank you.
Yes, absolutely.
Mr. Schmidt, I just have a question, and it might be for you or for your executive director. Sure. Around this very point. Mm-hmm. It seems like a couple of your initiatives in some cities went further than what at least the state said were permissible, and maybe some of the local officials. This process, I think we're trying to be as we're sticking within the law in terms of what we can do. Is there a process, or is there a political strategy in which you guys are employing when you push it just a little bit over, or how are you what is your thoughts in terms of the balancing act that I think that the city of Columbus is trying to walk?
That's definitely a question that our director, who is very intricate in a lot of these things, and he is the one who has written all the initiatives here in Ohio, and we're also in 4 other states with these initiatives too. He would definitely be able to go over that in detail with you.
Thank you, sir. Up next, we have Carrie Eckleberry. She had to leave. Okay. Did Commissioner Grace leave? Ms. Maudie Grace? Okay. Elder Larry Price. Welcome.
President Hardin and to Chair Favor, thank you for the invitation. The home want to put a face on the people. You know, I came prepared, the state rep and me came prepared with statistics, but we've shared the statistics. We know them. As chair of the Criminal Justice Committee of the NAACP, it is on our agenda this week for our executive committee and then our membership. So we will be back. And as Vice President of the Baptist Ministerial Alliance, it will be on our agenda Monday, and we will be back. And so I want to put a face on the people. People who have been institutionalized for marijuana, after they get out, they come home. We mentor them, we counsel them, we go to court with them, we feed them, we house them, and yes, we even hire them. They become productive members of our church. They join our choirs. They become members of our media ministry, usher board, food and clothing pantries. They become deacons and deaconess, and yes, even ministers. They are forgiven. But when they step outside the door of the church, where they have been forgiven and also given a second chance. And so President Hardin and Chair Favor, 3 of the things that you talked about, you sent me was 1, reducing penalties. As a former state rep, I share with her how tough that is. Working with statewide reform as a state rep, that's tough. Watch 3 strikes you out. Watch taking judicial, the ability for them to be able to make some discretion. Watch mandatory sentencing. But it's at the church where they're forgiven and they're given a second chance. Jobs are few, if any. Housing becomes an issue, therefore affecting them in being able to be good husbands, wives, fathers, mothers, daughters, and sons. So as we accept them, the church, society doesn't. They get frustrated, they get tired, day after day putting in applications only to be rejected. Rejection leads to depression. Depression leads to returning to their old ways. Old ways leads to the revolving door. And so I thank you, President Hardin, I thank you, Chair Favor, because what they need is a second chance. So if this can push the envelope, again, I talked about a little bit of the penalties, and I talked about obviously trying to work with statewide reform. But at the end of the day, all politics is local. So when you talk about home rule and the ability to institute things and then be overridden by the state, I think your job that you've set before you is an enormous job. But I think with the commitment of the city, the one thing, and I leave with this, and I've been, again, a former state rep, aide to a congressman, special assistant to the mayor, the greatness of Columbus is that Columbus way will always prevail when right prevails. Thank you.
Thank you very much. Our last speaker is Mr. Chad Thompson. Welcome, Mr. Thompson.
Thank you very much. What a speaker. I got to follow that guy. Thank you so much for the invitation. So my name is Chad Thompson. I'm the executive director of the Sensible Movement Coalition. We are the group, the nonprofit group that's responsible for enacting the local ballot initiatives and kind of pushing that movement across Ohio and across the nation. And I personally wrote that ordinance myself. I'm very directly, intimately familiar with Ohio law specifically. So I just want to say I'm going to probably give you some conflicting information, so don't be afraid to ask me any hard questions. Anything I say, it comes directly from the law or case law of Ohio. Obviously, law is up to interpretation sometimes, so these conversations have to happen. So essentially, I just want to address a couple things. First of all, the no penalty. In fact, Toledo originally passed an ordinance that included felonies as well, and that was done to challenge and see exactly what was possible. The AG essentially sued Toledo on that portion, leaving the currently enforceable ordinance, which is misdemeanors, down to all minor misdemeanor charges, no fine, no time, and we suspended court costs. The AG spokesman come out and said that they challenged everything they thought they could win. So, in fact, I know the case that was referenced, the Toledo case referenced no penalty as pugnatory. All the cases that were referenced, in fact, did not include a charge. So the difference is that the cases referenced were back in the 30s. It was a bank teller was essentially, they did a local ordinance that said you cannot do this, but gave absolutely no charge, no minor misdemeanor charge, no penalty. In our ordinance, there is a penalty, in fact. The minor misdemeanor itself is the penalty. Fines and jail time essentially are collateral consequences. So what we're telling you is, in fact, you can, in fact, go down to a $0 fine. Currently, there's 11 cities in Ohio that have that law that have not been challenged by the AG. And here's why it's important. We've heard all night about the problems about misdemeanor charges. There's no expert out there that will tell you the drug war has been a success. The good news is you have a chance right now to stop it. If you just penalize even down to $10, that racial discrepancy will not end. In Pittsburgh, it got worse. You have an opportunity to end the drug war right here in Columbus, and you are not the first city. There's other cities that are doing it. The AG is not going to sue you. This is allowed. If you have any questions, I mean, I would love to talk all night, but I know I have a limited amount of time. Is there any questions specifically? I also like the idea of the word cannabis. Unfortunately, in state law, it's spelled as marijuana, and I'm afraid changing that would potentially be a conflict.
Thank you for your comments, sir.
Thank you.
We appreciate your time.
Thank you.
Yes.
Thank you. Thank you, Chair. We just look forward to following up with you. It sounds like there's a layer or two of this conversation that would probably be helpful to me as a non-attorney. I always look to Chair Favor as an attorney and Solicitor General to get my questions answered, but to have just that another resource from the community is appreciated. So we'll have somebody from our staff follow up with you so we can get a meeting set up.
Absolutely. We've spoken before, and we'd love to continue that conversation.
Thank you.
Thank you.
Thank you. That does conclude our public testimony in today's public hearing. As chair of the Criminal Justice and Judiciary Committee, I'm passionate about improving the quality of life for all of our residents in every neighborhood throughout our capital city, which means that I am committed to having uncomfortable conversations that are critical to ensuring that every resident of Columbus is treated fairly under the law. Reform of any kind does not happen overnight. However, it's imperative that as legislators, we use this platform to raise awareness of issues and policies that have disparate enforcement and to advocate for change despite the legal and societal constraints. I would like to extend my appreciation to every guest speaker and to those who offered public testimony and took time out of your schedules to be here this afternoon, now evening. With that, I will turn it over to Council President Harden.
Thank you, Chair. I really don't have much more to add other than the thank yous that you added. Certainly thank you to you for your leadership and to the City Attorney's Office for the hours, also to the Mayor's Office, to Public Safety for the meetings and meetings and meetings that helped us get the conversation to where we are right now. With the disparities that we spoke about tonight, that we heard from leading experts on, the conversations that we heard from community testimony, it's hard to just go back to a business as usual with this conversation. Chair Favors is correct. This is not easy. And we are in a gray period in law and certainly in time, in history. But that does not mean or abdicate our responsibility as legislators to lead and lead with our values. And so we will move this conversation forward to continue to talk around penalties. We believe, one of the things that I heard that, and I think Elder Price hit on it too, is that for this really to be effective, we need partnership. So we need to hear from the judges. We need to hear from the prosecutor. We need to hear from the city attorney. We need to have them at the table. And so any conversation going forward, if we are able to get to a point where we can bring something forward, it will be through and after conversations with all of our partners. And I hope that we can get there. Secondly, around the work of record sealing, that work is critical to this conversation. I can make a commitment right now that this city council will do everything that we can to raise the profile and the platform, use our platform to make sure that every citizen that is eligible for record sealing knows how and where and can get to those services. And then thirdly, we know that this is a state, this issue is being advocated on at the state every day. We need folks in this room and folks around the city, folks who care about this, to go and make sure your voice is heard at the State House. These issues are affecting people in real ways, affecting families. And for us to have the ability to create real change, we need voices showing up in these chambers. But like we said, we will do all that we can do within our authority. I said earlier that one of the things that as a legislator that we always have to be cognizant of are the unintended consequences. And so we will dive deep. We said this is the first hearing, not the last hearing. So we look forward to your engagement. We're not going to dilly-dally around. We're going to be thoughtful and intentional about our conversations. And then when we have something I think that we can move forward to, we will come back to the public and engage. But I appreciate each and every one of your participation. Thank you.